So anyway, I was telling folks before we started that I have personal experience with ADA. I've broken 23 bones, been in a wheelchair 3 times, and it wasn't due to illness or anything like that. It was just stupid human tricks. And they all have a good story with each one of them. But I found out in a quick hurry that even a compliant facility can be very, very difficult to get around in. So with that, if you have questions, type them in your chat so that I can see them. That way it makes it a little easier versus unmuting and then trying to talk. So I'll go ahead and begin. So one of the things, and again, that's my wheelchair right there. It's a sports chair. It was really cool. I didn't need a ramp. I could take a curb in that thing. So so if we define disability, I think we all have different ideas of what that is, right? And everybody really they automatically think wheelchair. I mean, I used to do that same thing. Well, it's got to be wheelchair accessible. That's what disability is. And when in fact it's so much broader than that. So it can be a physical or mental impairment, and it can be seen or unseen, and it can limit your major life activities. And it can be anything from severe arthritis to, to wheelchairs, to canes, to crutches, to you name it. Pregnancy for a woman, I mean, certainly can be considered a disability. So when we consider that, all of a sudden facilities take on a whole different look in our mind. We all, because of our profession, we go into a facility and we say to ourselves, okay, well, I know where the exits are. We kind of look at type of construction and those kinds of things because that's where our focus is. Rarely is our focus on accessibility unless we're in a wheelchair or disabled in some way. And then secondly, the building officials themselves don't spend a lot of time on it, even though, chapter 10 and 11 in the building code addresses it, the ANSI 117. They perform a cursory review even on site, and I'm sure there's some exceptions to that, but I'm just basing this on my 27 years as a building official. And then we move on to the more compelling issues with the built environment. So why do we care about disability? We kind of look at that, have looked at it as kind of a bane. If you're a facilities owner, you say to yourself, well, I've got to comply with all this stuff, and does it really make a difference? And this perspective that I've got up on this screen, it's really interesting. So here's what it is. The goal is to afford every individual the opportunity to benefit from our country's businesses and services. Now here's where it gets interesting. And to afford our businesses and services the opportunity to benefit from the patronage of all Americans. And I've had a couple of clients, where we're going through litigation, and they say, well, I don't even want disabled people in my facility, this and that and the other. And I says, well, you have to consider, this last sentence. You need their patronage. That's why you're open for business, and you don't want to exclude any group of people from coming in and purchasing your services or products. So when you think about it in the light of that, and I don't know how many facilities owners we have here, but this really starts making sense. Okay, so again, a person may not appear to have a disability. They don't have to be visible, and they don't have to be disclosed. And you'll see a lot of that with service dogs. If someone comes into your establishment with a service dog, and restaurants are famous for this, they don't want a dog in the restaurant, obviously, but service dogs are allowed anywhere, and you're not allowed to ask them what their disability is. As it falls into the medical, the HIPAA thing, and it's also not allowed by the ADA standards of the Department of Justice. So think about that as well. That's actually my foot right there with that big bolt in it. And that's a really interesting story that I won't get into. But anyway, like I said, they can be seen or unseen. You just can't look at somebody and know whether or not they have a disability. Okay, so the regulations can be kind of tricky. And they're very complicated. They're kind of like the tax code in a way. Um, and some of the regulations are very, very precise. So you absolutely have to do it this way. Other regulations they give you a range, a measurement range. So, there's a little bit of fudge room in there, or, which is helpful to the designers, but a lot of the requirements in the standard are very, very strict and absolute. So they get real tricky. So the Civil Rights Act of 1964, which, is about discrimination, it's based on race, religion, sex, and so on. That's where the ADA came from. And as we started moving forward and really considering disabilities, they came up with the standard, the Act, in 1990, and now we've had it since then. So a lot of folks will say, well, this facility was built prior to that time, and we'll get into that. And it's not like the building codes where you say, well, it has to comply with the code that was in effect at the time it was built. And we'll get into that a little bit because there's some misunderstandings there. So the accessibility guidelines go through and address different elements. They break everything down in categories. And so they, everything from public accessible route from public transportation stops all the way in throughout your building, access to your goods and services, about cradle to grave, anything you can think of that's associated with the built environment has an ADA component to it. Okay, so public accommodations. If you're a facility owner, you are required to, I need to move this over because I can't read some of my slide. Anyway, you're required to have accessibility built in to your facility so that folks can, access your, restrooms and routes of travel to and from your restrooms to goods and services and those types of things. Now, there are different requirements for different types of buildings and uses. The exception is single family dwellings. If I'm a contractor developing a subdivision and I'm putting in 30 homes, I don't have to make any of those homes accessible. Now, the exception to that is if you have a multifamily building and and you have to make a certain number of them accessible, and so on. So single family dwellings, that's my house, your house, our individual homes, those don't have to be accessible. You can make them accessible, but it's not required. Okay. So public accommodations would include private entities that own, lease, or maintain a facility that's accessible to the public that provides some sort of goods or services. And the tenant is responsible for the accessibility features inside of their establishment. And, the landlord, for example, would be responsible for the site, accessibility. Now, this doesn't mean that you have an obligation as a facility owner to remove architectural barriers or those things that prevent people from using your facility that are disabled. Now, you certainly don't have to, remove any, structural elements or reconfigure any structural elements to do that. The standard addresses that, and they use this term readily achievable. And they also use another term, technically infeasible. So these terms you'll hear me talk a bit about, and they're pretty significant. Readily achievable is obviously something that you can do easily without a lot of expense or trouble. Now there's some exceptions to the readily achievable. If you're doing a remodel, then you have to make sure that that remodel conforms to the current standard. And the readily achievable means removing architectural barriers from existing buildings. It doesn't mean that you can, as new construction, say, well, it's going to cost me a lot to put in ADA or to make this accessible, so I'm going to consider that. I'm not going to consider that readily achievable. That doesn't, you can't use that get out of jail free card. So, okay, does government have to comply? Many times we think, well, the government is exempt, from a lot of requirements, and it's not the case here. This is a federal standard, and it's discrimination, based on discrimination, and the government itself is not exempt from compliance. And as a matter of fact, they can also be held accountable and sued for non-compliance. So, we think that we have immunity as government folks, when in actuality with this standard we do not. So yes, both the public and the government have to comply. Okay. So I'm going to talk about some applicable provisions from the Code of Federal Regulations, and just to make that easy, we just call it the standards for accessibility, Title II and Title III. Now, Title III is public accessible buildings like your stores and restaurants and those kinds of things, and Title II applies to the governmental buildings. And as a matter of fact, now if you get a government contract to build a building or design, you have to you're required to make it accessible and comply with the standard. So the standard is available. I don't want to spend too much time on this subject, but we know that the codes are available online, free, to view, the building codes and so on and so forth. However, they charge you for the book, whereas the government has felt this is important enough that they encourage you to download it. You can copy it. It's free. There's no charge. And you don't have to be signed up or a member of anything to access these standards. They want them available so that people, that they can encourage compliance with the standard. And I think that's, that's a good thing. That's a very good thing. So this is the standard that we go with today, the 2010 ADA standard for accessible design. And that's what we use today. The accessibility is enforced by the Department of Justice. That's where it lies with, like all other discrimination issues. It's also, the building official can also enforce this, and so on and so forth. So the additional standards that you'll use as well, obviously the building code, chapters 10 and 11, and the Uniform Federal Accessibility Standards, and also the ANSI 117.1A. All of them, I've sat on these code change hearings, and we've always bantered about, why does the building code even address accessibility if we've got the 2010 standard, and why do we even need the ANSI 117 if we've got the 2010 standard? Because they all say the same things. The building code, arguing for that with the building code, it forces an architect or a designer or a facility owner to actually implement those standards into a building, and they can be looked at as codes. Typically, they're a civil rights law. The ADA standards are a civil rights law, and they're not a building code. But the good thing about the ADA standards is that you don't get into the mess of the building code where it says, it has to comply with the code that was in effect at the time the building was built. The standards apply to a building that could have been even historical buildings. So there are certain requirements to remove architectural barriers, and there's certain allowances for historical buildings, but nevertheless, all facilities, older facilities, it doesn't matter when they were built, are required to comply with some part of the standard. So that's between the building code, the ANSI, and the ADA standards, there's really not a way to get out of compliance or to skirt the issue. Okay, so as a designer, you want to look at the entire design of your facility, what you're proposing, and you want to make sure that that you're following some principles and some guidelines, and these principles help us wrap our mind around a perspective, I guess, take a perspective when we're designing a building, when we're building something. And these are the things that are important. So you have equitable use. That means everybody, without exception, is able to use that facility. And I can go down and read every one of these, but they're pretty self-explanatory. The one I do want to talk about is tolerance for error, and I mentioned that before. Tolerance for error, like I said, some of the standards have a range where you can, for compliance, reach ranges, knee space, those kinds of things, countertop heights, and then some are very, very strict, where there's no fudge room. So, and those that are very strict, it's possible to comply. They're not giving you a requirement that just makes it impossible to build something. So, and again, low physical effort, size and space for approach and use. We have a problem with this many times in retail, where the aisles, you go down the aisles and they're just not wide enough. You can't turn around. You'll get to the checkout counter and it's high. There's no low portions for people that are in a wheelchair. Reach ranges are completely off, and so on and so forth. So those, if architects and designers follow these principles and that's their perspective while they're designing a structure, at the end of the day, they'll intuitively follow the ADA standards. So again, let's talk a little bit about enforcement. So the building official obviously can enforce the standards. They're allowed to do that. The Department of Justice also does. You probably don't want to get to the point where the Department of Justice is involved in this. That usually means you've been sued for non-compliance. And so it's important to understand when am I required to comply? So if I had a structure that was built in 1960 and then I did some remodeling, do I have to comply with the ADA? And the answer to that is yes, to a certain extent. So what they base that on is the standards for new construction is the last application for a building permit or permit extension is certified to be complete by a state, county, or local government. So if you go out and get a building permit for your remodel and you do that, say you got the permit in 2011, you'd be subject to the 2010 standard. And if say you got it in 2020, you'd still be subject to the 2010 standard, and then also the provisions of the building code and the ANSI. So they base it on when the permit was taken out. Now, if you got a permit before 2010, you're in the 90s, so the 91 code. So okay, so let me go back here. Okay, so let's talk about new buildings and facilities for a minute. So the minimum requirements for both scoping and technical for newly designed and constructed or altered state and local government facilities, public accommodations, and commercial facilities must be readily accessible and usable by individuals with disabilities. And so I run into I'll give you an example. If you restripe a parking lot, and that's considered an improvement, and therefore you're required to comply with the ADA standards. And if I had a case I worked on where they restriped a parking lot and the drainage contours for the parking lot were really extreme. I mean, the slope issues were crazy. And because they restriped the parking lot, they had to go in and modify those slopes because they couldn't get a parking space that had less than 1 in 48 slope. They couldn't get their accessible routes or their access aisles to line up, and they had all sorts of cross slope issues. So it's really those triggers. We'll talk about those triggers, but it's really important to keep this in mind. And again, facility owners and managers and maintenance folks, it's just not on their radar. And so it only gets on their radar when they get sued over it. And then it usually, sometimes the cost of the lawsuit is far greater than the cost of complying with the standard, which is unfortunate. I think we see that across the spectrum in our industry. So we need to design and construct those in such a manner that each part of the facility is readily accessible by an individual with disabilities. And when you say each part of the facility, what does that mean? So if you're running a hotel, there's a ratio of rooms that have to be accessible. Features in the hotel, drinking fountains, and this applies to other than hotels, but hotels have some unique requirements in and of themselves. And so the reach ranges for goods and services, for your ATM machines, for your snack dispensing, vending machines, those kinds of things that we never really think about, and the maneuvering space around those things is important. And these are areas that are common violations, because it's not it's not on their radar. They're not professionals, in the industry. They don't see it that way, and they only find out about it once they're being sued. Real quickly, I had a litigation that I worked on where there's a group that goes around and just identifies accessibility issues, and then they file a suit in federal court. And this facility, the only problem with this facility is it had its parking sign was too low. It's got to be 60 inches to the bottom of the sign, where you pull into the accessible parking space and you see the sign with the wheelchair on it. That was too low, and that's probably a $100 fix. Well, by the time we went through and I came out and looked at it, and he had to hire an attorney and he had to pay the other's attorney's fees because he did indeed have a violation, that ran him about $5,000 for a $100 fixable issue. So being proactive is very, very critical, and we'll talk about that in a bit. Okay, so new construction and alterations. As I said before, if you make an alteration to your facility, even something that seems as harmless as restriping your parking lot, you're going to be required to bring things up to the current standards, and it applies everywhere. As I said, there's a list on the left. Social service centers, housing at a place of education, assembly areas, medical care facilities. If you restripe your parking lot, you may have to change your curb ramps, and again, facilities with residential dwelling units for sale to individual owners, multifamily dwellings, those kinds of things, you're going to have to comply. Courts, detentional and correctional facilities. We often look at that and think, the court, how, they're the ones that tell us what is, and they're not exempt from this either. So again, Title III entitles the undertaking for readily achievable barrier removal. And readily achievable, I talked about that before, means easily accomplished, and you can carry it out with much expense. And there's a trigger for that that I'll get into in a minute, that that relates to the expense of things. And in my profession as a building official, we do a plan check, or we go out and do an inspection, and I often heard, well, I can't afford to do that. Is there some sort of an exemption? And when it comes to the building code, certainly not based on cost. You're required to comply with the code. It's not based on how much it costs you to comply with the code. But there are some exceptions in the ADA standard that deal with proportionality, and based on how much things cost to remove a barrier. If it's new construction, you don't get that benefit. But if it's an existing facility and you're remodeling it, it requires that you do your best to make it accessible. And when they put language in there like that, it just invites argument. But I would say if you worked with your designer, your architect, closely, you can make it as best as you can. Certainly in historical buildings, things aren't always possible, or in older buildings, and it's not always possible. But readily achievable. They look at that. The Department of Justice looks at that very closely, and makes determinations based on that. So structural and practicability. So that, say you're doing a remodel and you have a structural column or a beam, or some sort of a structural configuration that does not allow you to get the full access space in a restroom. Say if you can't make the restroom fully compliant with a turning radius and all of those things because you have structural elements that prohibit you from doing that. That is allowed. You do the best you can. You shouldn't have to tear your building down and build a new building in order to comply with the ADA. And certainly they understand that. So they give you that exemption to be able to go in and do the best you can. If you've got structural elements in the way, then you certainly have exemptions for those. So again, alterations. This is Ivy Place. The picture here is Ivy Place, right over off of Van Winkle, for those of you who are familiar with that. There's a big shopping center, strip mall, that's been there since the 60s. And they were sued by a group out of Florida. And one of the things that they were trying to argue was that, well, this facility was built in the 60s. I mean, isn't there some exemptions? And some of the structural, if it was structurally impractical to change some things, that came into effect on the interior of this building in a couple of cases. But they restriped their parking lot, and then they had all sorts of violations with the curb ramps and parking spaces, slope and cross slope. It just created a myriad of problems, and they're required to fully comply with the standard once they make that alteration. And restriping your parking lot, as I said before, is considered an alteration. Okay, and if you change out the doors going into your store, then your push force and pull force, those have to comply at the 5-pound rule, and your accessible routes have to comply, and those types of things. So even if it's a part of a facility or the full facility that you're changing, if you're making any alteration. So here's where I spoke about disproportionality. And there's kind of a general 20% rule. So if the cost of the alteration is, if to make it ADA compliant exceeds this 20% in relation to the cost of the alteration, then you can get some exemptions here. You do the best you can, but it can't be so disproportionate that it would be more economically feasible just to build a new building. That's not where they want to go with this. So if you can't make it fully accessible, you're still required, even if you use this disproportionality exemption, you're still required to do the best you can. Okay, it doesn't mean you don't have to address it at all. It just means you do make it the best it can be made without incurring disproportionate costs. So there are very few exceptions to compliance with the standard, but I think these are some reasonable exceptions, and I think it was wise that they addressed this, as well as the structural elements. Otherwise, like I tell folks in the construction world, we're not building pianos here, and there's got to be some give and take in the built environment. Everything can't be exactly precise and exactly perfect, but we do the best we can, and the building codes are minimum standards, as we've all heard. So that sheds some light on the thought, behind codes and standards. So let's talk about landlords and tenants. In most of the litigations that I've worked on with involving a landlord-tenant situation, there's this argument that arises about who is responsible for what. The tenant obviously wants to put it all on the landlord and say, hey, I don't own this facility. I just rent it. So the building owner is responsible to make it comply. And that's not entirely true. So when you consider the tenant's responsibility, certainly those tenants are going to be putting in shelving, or say it's a hair salon, their chairs, all of those kinds of things. It could be a O'Reilly Auto Parts, and someone else owns the building, but they're in there doing their thing. Their area that they lease has to be compliant, and they're responsible to do that. I had one scenario where Intermountain Healthcare owned the building, but Red Cross was the tenant, and this thing had so many violations. I mean, it was a small space, but I ran out of my pen ran out of ink on this, and so Intermountain Healthcare uses this as to determine whether the facility is even feasible, whether they want to keep it or get rid of it. And so the tenants, Red Cross, they were required to make it accessible, even though Intermountain Healthcare owned the facility. So, and if the tenant does alterations and makes their space accessible, this doesn't necessarily trigger, the landlord to have to go out and completely redo their parking lot and all of their curb ramps and everything else. Although they, it's always important, they are still required to remove architectural barriers, but it doesn't trigger that if the tenant makes improvements. So what are some common issues that we face? I'll go through those because they seem to be the bulk of the litigation that I deal with, or else they're the beginning, okay, because they're really easy to notice. So if someone's just driving through your parking lot and they see signs that are not compliant, and I want you to pay attention. This is kind of some homework for you. The next time you go, visit a restaurant or a store, I want you to look at their accessible parking and then the accessible route from their accessible parking to their front door. And more often than not, you can find violations, whether it's slope, cross slope, width of the access aisle, connection of the access aisles and the parking spaces to the accessible route, and how all of that works. And those are usually the things that invite someone to file a complaint, especially if that's what they do. I was talking before our session began, and it was talking about a group that there's a couple of groups that that's their purpose. They go around, they look for violations, and then they file a claim in federal court, and that's how they make their living. And they have attorneys on staff and then some inspectors on staff, and then they go write up this huge list of violations, or even one violation. But once you have one, that kind of opens the door for them to come in and look at everything you've got. And if you're looking for them, you'll find them, no question. So now we start really getting into risk and how we're going to manage that. So this is one area that you really get hammered on, parking. and exterior accessible routes and things like that. That's where you'll get it. Curb ramps are another famous one. They're very popular. People will look at those and say, okay, they don't meet these dimension requirements, and they'll file a claim. Another one is when they go into your facility, these are other very common issues or violations or reach ranges. And when you start looking at this, you can see how specific these are. Okay, and I don't know of a facility owner that knows this. I really don't. I've never met one that says, "Oh yeah, okay, this is my reach range, and these are the dimensions that I need to comply with," and they just know those off the top of their head. They just don't know them, and so they may make an alteration that requires compliance with these provisions, and it's just not on their radar. So. And I think that's where the disconnect is, and that's where the real risk comes into play. I mean, certainly if we didn't have these issues, we wouldn't have our jobs, or our professions that we do to help people, deal with these. But the expectation that a facility owner is going to know these things it's pretty rare that they do. And accessible routes is another one that's very common. Now, when I get into these things about, these things I'm talking about the flags or the easy things that they notice, these are also fairly easy things to resolve. And it falls into that readily achievable category. And, if you have to adjust some shelving or an approach area, provide some maneuvering space by moving some things around, that's readily achievable. If you have to change your curb ramp so that it complies with the standard, that's readily achievable. So these things are easy fixes. They're the low-hanging fruit, but they're also the ones that invite scrutiny. So you want to be really, really careful with those. And again, those are the things that make you a target. It can be something as simple as the sign that I spoke to you about, and the cost of something like that is pretty great when you consider, again, it was $100 to fix it and $5,000 to deal with the claim. So when ADA requirements are overlooked, whether you're doing a remodel or you just or they're just there and you're not aware of them. Those are architectural barriers that should be removed, and nobody pays attention to them. And then that makes you a target, even the mere existence of them. And again, just that not paying attention to architectural barriers, whether you're making an alteration or whether they just exist as they are. This is where mitigation can play a big role. As attorneys, you guys are kind of on the response end of things. You're really not involved until someone gets sued, and then you respond. But if you look at it like like public safety, where we go and do fire prevention. Okay, I did fire prevention and fire investigations for a lot of years with the county. And so you have this prevention and mitigation that you do to kind of address things or problems that may be lying in wait. And you try to address those problems and resolve those ahead of time, and not when they become an issue. So where do you begin on all of this stuff? I mean, how do you get a facility owner to address all of these things and become aware of them? Well, that's still the challenge, but I think if we break it up and kind of educate facilities maintenance folks or even facilities owners to take kind of a phased approach to things. They just kind of need to break things down into manageable pieces. So as I spoke about before, your accessible approach and entrance is what invites folks to, to file claims and to notice violations. So you need to address those. That would be I would say, priority one. And then access to your goods and services. Certainly if someone comes into your facility and they can't maneuver or they can't reach or they can't even go to your checkout aisle without, having to, to put something on their lap in order to write you a check, that's, or pay for your goods, that doesn't work. So just those very simple access to goods and services. And again, look at it with a mindset of, equitable use, so that anybody could go in and purchase your goods or take advantage of your services. And then 3 is restrooms. Restrooms will get you. That's another area that people notice. And those are very obvious ones. When you get into the restroom and you can't turn around, you can't access a stall. The flush controls are wrong. You can't reach the faucets. You can't, pull a paper towel out of the dispenser because it's too difficult. Again, door push resistance, it required to be 5 pounds. And I'm a pretty capable guy. When I was in a wheelchair, all 3 times it was even difficult for me to open some doors. They probably had 20, 30 pounds of pull force that was required to get the thing open. And then you had to prop it with your foot and then kind of make your way through it. And the closure was too fast beyond the 12-second or the 12 degree, 5 seconds, 12 degrees. You could not get past those doors. So things like that are just so obvious, to someone that has a disability, where they're not obvious to us as, very ambulatory people that go around every day and are used to things like that and have our grip strength and have those kinds of things. And I don't, maybe consider any difficulties that you have getting in. Even as an ambulatory person, sometimes we say, wow, that door was hard to open, or I couldn't get past that, those 2 shelves, or I, couldn't reach this. Think about that. And then when you think about that and you experience that, think about that in context of a disabled person. Now, when we say other measures on priority 4, we often forget hearing impaired folks, things like that. I struggle with that myself. Working on construction sites for so long that, and not paying attention to hearing protection, that's had an impact on my hearing. But when you get into assembly areas where they're having a conference and is there equipment in there that's accessible and available to persons with hearing disabilities? There has to be. It's required to be. So those kinds of things. Think outside of the context of someone in a wheelchair. Hearing loss is a disability. Vision is certainly a disability. And those kinds of things. So other measures, that's what we're referring to in priority 4. Okay, I'm going to check my time real quick. I don't want to go over. Okay, I got about 10 minutes left. Okay, so we've looked at all of this stuff and the regulations and common violations and all of that stuff, but really, what does that mean? I mean, do we have to go out and just address everything right now? Do we, what can we do ahead of time? What's going to help us? If somebody comes up and sues us, then we have to turn around and spend thousands and thousands of dollars to fix everything at once. And I don't think that everybody's on a budget. Every facility owner, they have a budget, and there's things that they're putting off for next year, following year. They might have a capital improvement plan that it's going to, take 3 years, to do all the changes that they want to make all the changes they want to make. And that's just them thinking about their normal maintenance or their any improvements they want to make. If they want to do a remodel, maybe it's 2 years out. And so what needs to happen is they need to incorporate barrier removal into their capital improvements or their facility improvements, as for the next 3 years or 5 years or whatever their plan is. So they have to have a plan. They should have a plan. They don't have to have a plan. They should have a plan. And the DOJ considers that a good faith effort to comply. So let's assume that a facility owner has this plan. It addresses barrier removal. They have a budget assigned to that, and it's referenced in the plan. And someone comes along and sues them for an ADA violation. So this is super helpful if they have a plan in place, because what that proves to the court is that, hey, this is on our radar. We know it's a problem. We're going to address it. And, we're addressing these things first, the low-hanging fruit. We've already made some changes. We're already addressing things. So it's very unlikely that a judge is going to look at that and throw the book at these guys, throw the book at someone that's got a plan. Okay. If you have an existing facility, you are not required to go out tomorrow and remove all of your architectural barriers. It's not something that's realistic. It's not something that you're required to do. That's not to say that you shouldn't have a plan. If you have a plan, that looks very favorable in the eyes of the court. And so as a facility owner, that would be super important. So how do we go about developing a plan? So first off, you've got to know, you got to be aware of the barriers that are existing at your facility. Now, remember, you've got to look at this from sometimes from the public transportation stop. So you have a bus stop that's 200 feet away from a facility, and then they have to get on a public sidewalk and they have to make it all the way to your front door. You've got to take that into consideration. If the accessible route from the public access has got slope issues, cross slope issues, or there is just plain isn't one, you've got to take that into consideration. So assessment and survey. You've got to perform an assessment and a survey. You've got to understand what barriers are there. And if you're going to do an alteration, what you have to comply with, and those kinds of things. And so then you're going to develop a plan to resolve those issues and resolve as many of those issues beforehand. So again, it's if it's something that once you do an assessment, you're now aware, and I guess in the attorneys call this notice. You have notice that these things exist, and you're required to either have a plan to remove them or to remove those barriers. Okay, so you want to prioritize and address those target areas that I spoke about in this slide right here. That's the best way to go about it. So in your plan, kind of structure it this way with your priorities, and then and when you're gonna fix those. Now, response is an interesting thing. By the time we get to that point, we've probably been sued over something, and now we're scrambling trying to figure out how to address that. At the same time, how to resolve and remove these barriers, and that things start getting really expensive. In the emergency management world, we have with FEMA has this analysis that they've done where for every dollar you spend on mitigation, you save up to $4 on response and recovery. So that's a pretty good investment, and that's very conservative. 1 to 4 ratio is very conservative. I've heard it as high as 7. um, but conservatively 1 to 4. So if you get noticed, act quickly. So many times I go work on a case and they waited until it was a critical mass before they even talked to their attorney about this. And then everybody's scrambling trying to get things, submitted and assessed and, analyzed, and everybody's scrambling trying to do that. And that's never good for anybody. And it can get really pricey and you can miss things. So act quickly. If you get served, make sure that you start addressing that right away. Now, the other option is you don't do anything, and hope is never a good plan. Hope that nothing happens. That's never a good plan, and it's very, very poor risk management thinking. So as we consider risk in the grand scheme of things, as I've gone through in my presentation, the risk of not doing something at all can get very expensive, as I've talked about, especially if you have things that make you a target, and you're just kind of hoping that nobody notices it, or I'm not going to make a plan. I'm not going to, go through and identify the problems that I have existing on my site or in my facility. I'm just going to, go along and I got better things to do. I'm not going to address any of that or even, make it a priority to look at it. So that's just very, very poor risk management, and it's very pricey, very expensive. So with that, I'll take some questions and I can revisit any of these topics with you if you need me to. And
may I ask the first question?
Sure.
We know that Salt Lake is a big municipality, and so do these issues get checked with the building when you get your building permit approval? When you get your
Yeah, to some extent they do. And that's where the ANSI comes in, and they rarely crack open the 2010 standards that are very comprehensive. The ANSI standard and the building code just pull some highlights out of the ADA standard. But it depends on how sophisticated your plan reviewer is and your inspector. I was working on a case where I had the building official for that jurisdiction actually come up to me and say, I don't know anything about ADA, and this was probably within the last year. I don't know anything about ADA. Can you give me your phone number, and if I have questions, can I just call you? And so, it depends on the jurisdiction. And, so many times we hear contractors say, well, it wasn't on my plan, or they didn't talk to me about it during my plan review. And so, they therefore think that they don't have to comply. But to answer your question, Eugene, yeah, they do perform some level of review. How thorough and accurate that review is, it's Salt Lake City, for example, is pretty good. But I would
the outliers,
the outliers may not be, and I wouldn't even completely trust any jurisdiction to be as thorough as you actually need to be. I would work very closely with your architect on this. That's where it's going to make or break the situation. And some architects, they're not very knowledgeable about accessibility, and some are very, very knowledgeable. But then, I was doing a big project up in Salt Lake City with Big D on the Morton building, and the architect had called out all of the things, and as we all know, that what looks good on paper doesn't always work out in the real world. And they had all the referenced codes and standards that applied to the ADA situation in that building, but some of those things were just because of the space constraints and how they were configured. It was almost impossible to comply. So we had to manage that during the construction process, which was a little bit tricky, but we were able to do it. So, you know, that's where builders really kind of drop the ball, is they don't have somebody on staff or that they're contracting with on site to really put eyes on these things and deconflict them as they're being built. And that's a big gap. So
Next question: how common are lawsuits associated with ADA?
more common every day. They're almost an epidemic, I would say, because they're easy. They're easy. You know, if I was on the other side of this, I could stay in business. I could create more business than I would have time to even do by suing people over ADA issues. They're very, very common. Just to put that into context, there's a group out of Florida that will get on Google Earth and they will look at fairly large facilities like a Home Depot or a shopping center, and they will, this tells you how common it is and how prevalent. They will actually fly some inspectors out from Florida to Utah, and their inspectors will go on site and go around and take note of everything that's wrong, and then they'll file a claim in federal court. And it's big money. It's real big money. It's a business that's never, I guess it's probably one of the most, it's like our industry. It's very sustainable. I mean, people are never going to stop suing each other, but yeah, it's very, very common. I don't have the stats off the top of my head, but in Utah County, there was a local firm that was going around doing this, and it was hundreds. It literally hundreds. So yeah, it's on everybody's radar. Really, it's easy money. So,
Michael, thank you very much for your presentation. Very timely information. This session has been recorded, and although we have a bunch of people watching currently, there will be quite a few more people who will also watch this, because we'll put it up on our website. And these sessions are approved by the state bar for self-study type of CLE credits. So again, thank you very much, Michael.
You're more than welcome. It's been my pleasure.
We appreciate that, and we'll let people take one last look at your